So, good afternoon to you all. I'm very pleased to be part of this panel, to chair this panel, and at the same time, I'm excited to listen to our speakers. I sincerely thank for not only for their participation to this final conference of the ELaN project, but most of all for their presence here in Pisa. Please switch off your microphone when you connect to Team. Okay, thank you. It's okay. Yes. My voice is a bit low because autumn is just arrived. It's a wonderful season, but I already catch my cold. This afternoon, we are going to talk about access to justice and gender-based violence. And well, the punitive response to gendered violence is maybe one of the main legal trends in the last decades, especially the last 2 decades in the European context, where the complex phenomenon of gender-based violence has been counteracted, contrasted, especially through the criminal law, by providing new crimes, increasing the penalties, excluding those sanctions, those punitive solutions that avoid detention, and providing the criminal procedure of measures specifically aimed at protecting victims of family and relational violence. Indeed, it is a matter of fact that following the Istanbul Convention and somehow anticipating an EU binding document, which is currently under parliamentary discussion in the form of proposal for a directive, European countries, a great part of European countries have so far adopted regulatory frames punishing violence against women and domestic violence in their main forms, in line with the positive obligation deriving from Articles 2 and 3 of the European Convention on Human Rights. Sexual violence, domestic violence, and violence in close relationships are foreseen as crimes and often as the most serious ones. Therefore, it could appear a bit bizarre, maybe, the choice to reserve this pen to access to justice and gender-based violence as the wide and often harsh criminalization and punishment of gender-based violence formally, I'd stress, formally entitles victims and public authorities in prosecuting and punishing these behaviors. But as we know, things could and things should be better. Looking at Italy, we are aware, and I'd say we have been made aware by Grevio that our legal system still needs to be improved to reach the gold standard of the Istanbul Convention regarding the Italian system of criminal justice, for instance. An explicit relevance still must be given to the consent in the structure of a crime of rape, so that victims will not be asked to give positive evidence of a negative fact, such as their refuse to the sexual act. Moreover, we are still missing, and every day we are missing, provision or a set of provisions specifically dedicated to the judicial assessment of the risk of lethality, as required by Article 51 of the Istanbul Convention. And this is a lack of regulation that exposes victims to a higher danger of repeated violence or to further escalation of it. Nonetheless, both Grevio And the European Court of Human Rights recognized that our legal system in the complex, our legal system has been equipped with several provisions, both on the substantive and procedural sides, to contrast domestic violence and relational violence with the proper criminal measures. But despite these several reforms of the last years, access to justice in cases of gendered violence remains a problematic issue. On closer inspection, indeed, it is not in the law, in the books, in our codes, that the main obstacles to effective access to justice lurk. Rather, in its concrete application by the public authorities, by the judicial authorities. Hence, even where the regulatory framework is, after all, in line with the provisions of the Istanbul Convention and the European Convention on Human Rights, too often victims must face practical interpretations and applications that jeopardize their full and effective access to justice. Still, the structural dimension of gendered violence and its deeply planted roots in our social cultural grounds become stereotypes and prejudices affecting the judicial authorities as well. Minimization of violence, often reduced to a conflict between partners, is one of the problems pointed out in one of the last pronouncements of the European Court in a case involving Italy, victim blaming, the use of a myth of rape. They all make investigations and procedural issues low and ineffective and expose victims to further victimization, both as secondary victimization and as repeated victimization, with the consequence that the authorities fail in their obligation to protect them. So improvements are required in the national criminal laws to fill the gap. Specific training on the features of gender-based violence are necessary for all the professionals of the criminal trial, judges, prosecutors, police, lawyers, to make them aware of the specific features of gender-based violence and to let them detect the victim's needs. And more attention must be paid to the needs of victims of violence, of this kind of violence, to understand which is their interest in accessing to criminal justice, and which is the aim of accessing to criminal justice. Indeed, criminal justice is necessary to combat gender-based violence, but at the same time, criminal justice, the criminal trial, is not at no cost for victims of violence. Secondary victimization and repeated victimization are the main risks for victims of gendered violence, and they are two sides of a same coin thrown in the criminal trial. Criminal proceedings offer protection from repeated victimization, from further violence, but at the same time, criminal proceedings expose victims to secondary victimization. We can mitigate the risk of harm inside the trial, during the trial, by limiting the cross-examination. That's what is happening in the Italian criminal trial, reducing the number of victims' testimonies, training the judicial professionals to a respectful way of approaching the victim. But nonetheless, the courtroom will never be an hospital place for victims, as the criminal trial is and must be accused-centered. So putting victims' needs and interest aside. The purpose of this panel is to explore and understand, with the help of our brilliant and distinguished speakers, whatever victims of gender-based violence need to get effective access to justice. What do victims of gendered violence need? Which are the hurdles that the very same victims must overcome, and what kind of justice are they looking for in order to find an answer to their needs and interests? And let's talk about it with Roberta Rossi. Roberta is a lawyer of the Florence Bar Association, who recently, in last April 2022, represented the victim in an important case, Landi versus Italy, in front of the European Court of Human Rights. And she will point out the pivotal role of the European Court in granting a full access to justice in order to respond to the primary need of victims. They need to be protected from offenses and from the escalation of violence. Indeed, during the last months, Italy has been repeatedly stigmatized because of a lack of protection within the criminal procedure and civil justice as well, due to the authorities' inaction, not only in the case Landi versus Italy of last April, but in the case De Giorgi versus Italy of June 2022, MS versus Italy of July 2022, and besides the European Court's judgment, raised the CEDAW committee that last June stigmatized our country as well. And this series of pronounces marks a worrying sequence of decisions that highlights inertia, delays, and underestimation of Italian authorities, due mostly to the lack of knowledge of the phenomenon and the cultural inability that they still have to read in a way that is free from prejudice. From this point of view, the case Landi versus Italy is an emblematic one, both for the attention paid to the need for protection and for some very interesting procedural issues, which are strictly related to the topic of access to justice. Therefore, I'm thankful to Roberta Rossi for taking her experience and insights on the case. So Roberta, the floor is yours. Thank you very much.
Thank you. No. Volevo mettere come diapositiva.
La visualizzazione.
Sì, senza Facciamo così. Facciamo così.
Someone can help us to change the format. Is it okay? Okay. So
let's go. Good afternoon. Let me thank Professor Valentina Bonini for the invitation. As Professor Bonini said, we will talk about the Landi proceeding that I followed with my law firm, and which brought us to submit an application against the Italian state with the European Court of Human Rights. Ms. Landi alleged that the Italian state had failed to take the requisite action to protect her and their two children from the domestic violence inflicted by her partner, which had led to the murder of her one-year-old son and their own and their daughter attempted murder. The relationship between Ms. Landi and her partner, NP, started in 2010. They had two children, V, a girl born in 2011, and M, a boy born in 2017. Between November 2015 and September 2018, Ms. Landi sustained 4 attacks by her partner, after each of which the police, Carabinieri, intervened. Ms. Landi had lodged and then withdrawn several complaints. However, proceedings had been commenced against NP on charges of domestic violence, but no orders had been issued for the protection of Miss Landi and her children during the investigation. Indeed, the first report concerning NP's violent behavior was made by Miss Landi in front of Carabinieri in November 2015. She reported that in several occasions, NP had kicked, stretched, and beaten her, and she also referred that she used to threaten her, telling her phrases such as, "I'll kill you," or "I scare you with the acid," and so on. On the 22nd of November, the police sent to the public prosecutor a communication of criminal offense concerning the man. They informed the office of the public prosecutor that he had obtained an order of ban on approach with his previous partner and recommended the public prosecutor to ask the judge for a precautionary measure concerning the estrangement from his family and a ban on approach with Miss Landi and her daughter. After that, a proceeding was opened against MP for stalking and damage. Actually, no investigative steps had been taken by the public prosecutor, who didn't take any measures to protect her despite the recommendation of Carabinieri. After 4 months, Miss Landi decided to withdraw the complaint. Consequently, the proceeding was dismissed. The 1st of September 2017, the second child of the couple, M, was born. On the 6th of September, very few days after M's birth, the second attack was committed by NP against Miss Landi. She asked the intervention of the authorities. On the 9th of September, the police sent the public prosecutor a communication of a criminal offense, and the proceeding against NP was opened. Once again, no investigative steps were taken by the public prosecutor, and the proceeding was dismissed. On December 2017, the police drew up a report in which they referred that they had seen Miss Landi and her partner arguing with emphasis. The police referred that it was clear that the woman needed help during the discussion. MP was reported because he refused to give his personal information and he didn't want to be identified. On the 22nd of February 2018, Miss Landi asked the intervention of the authorities, complaining the unthinked aggression by MP. After that, the man was taken to attack committed by MP against Miss Landi. The day after, Miss Landi went to police station and referred that during the last months, she had to suffer indignities and threats, like "I'll kill you," and in particular, "I'll kill your kids." On the 26th of February, MP was discharged from the psychiatric service with a specific drug therapy, which needed to be continued at home. On the 28th of February, the applicant withdrew the complaint, according to what the psychiatrists recommend. After the withdrawing of the criminal complaint, on the 2nd of March 2018, the police sent to the public prosecutor a communication of a criminal offense for ill treatments and injuries, and recommended the office of the public prosecutor to ask the judge for a precautionary measure. A proceeding against MP was opened. During the time of the investigations, nevertheless, the effective dangerousness of NP, no precautionary measures had been taken. In the end, after several violent behavior committed against Miss Landi, on the 14th of September 2018, just before dinner, NP took a kitchen knife and killed his little son. Moreover, he tried to kill his partner, inflicting her several serious injuries, and their daughter. MP was arrested, and the proceeding against him was opened with the charges of the homicide of his little son, M, and attempted murder of Miss Landi and of their daughter, V. In October 2019, NP has been sentenced to 20 years imprisonment and ordered to pay 100,000 euros to Miss Landi and their daughter, V, who had joined the criminal proceeding as civil party. After M's death, Miss Landi lodged an application against the Italian state with the European Charter of Human Rights, alleging that the failure by the authorities to comply with their obligation to protect her life and that of her son, who was killed by her partner, had resulted in a violation of Article 2 of the Convention. She submitted that the Italian authorities had been negligent before the repeated violence, threats, and injuries which she herself had endured. According to the Cards case law, the positive obligation under Article 2 of the Convention imposes a primary duty on the state to secure the right to life. This requires the state not only to refrain from the intentional taking of life, but also to take appropriate steps to safeguard the lives of those within the jurisdiction. This could also imply, in certain circumstances, a positive obligation on the authorities to take preventive operational measures to protect an individual whose life is at risk from the criminal acts of another individual. This basic principle was for the first time affirmed in the leading case, Osman versus United Kingdom, in 1998. Having regard to the nature of the right protected by Article 2, a core right in the scheme of the Convention, it's sufficient for an applicant to show that the authorities didn't do all that could be reasonably expected of them to avoid a real and immediate risk to life of which they have or ought to have knowledge. According to the so-called Osman test, it must be established that the authorities knew or ought to have known at the relevant time of the existence of a real and immediate risk to the life of an identified individual from the criminal acts of a third party, and that they failed to take measures within the scope of the powers which judge reasonably might have been expected to avoid that risk. The court held in Osman that this obligation must be interpreted in a way which does not impose an impossible or disproportionate burden on the authorities. This is a question which can only be answered in the light of all the circumstances of any particular case. Another relevant consideration is the need to ensure that the police exercise their power to control and prevent crime in a manner which fully respects the due process and other guarantees contained in Article 5 and 8 of the Convention. After Osman, the case law Opus versus Turkey and Talpis versus Italy adapted and developed the application of the Osman test in the context of domestic violence. According to these leading cases, children and other vulnerable individuals, into which category fall victims of domestic violence, in particular are entitled to state protection in the form of effective deterrence against such serious breaches of personal integrity. The fundamentals of domestic violence show that children are always affected by violence in the family unit. Violence against children belonging to the common household, including deadly violence, may be used by perpetrators as the ultimate form of punishment against their partner. Intimate partner violence is never limited to the direct victim, which is why equal measures have to be taken to protect the children, even more so if the children had already been directly affected by violence and been the target of death threats. Another leading case is Arte versus Austria, the Greek Chamber, very recent, 2021. This leading case clarified that the existence of a real and immediate risk to life must be assessed, taking into account of the particular context of domestic violence. In such a situation, it's above all a question of taking account of the recurrence of successive episodes of violence within the family unit. It's well known that domestic violence is never a one-off event. It often constitutes not just an isolated accident, but rather a continuous practice of intimidation and abuse. As long as an offender is not successfully kept from contacting the victims, the risk of further violence remains. Therefore, the state authorities should react with due diligence to each and every act of domestic violence and take all necessary measures to make sure that such acts do not lead to more serious consequences. It follows that the duty to prevent and protect comes into play when the risk to life is present, even if it's not imminent. Judge Pinto d'Albuquerque expressed several years ago, in his concurring opinion in the case of ELaN versus Lithuania, that realistically speaking, at the stage of an immediate risk, the victim is often too late for the state to intervene. In addition, the recurrence and escalation inherent in most cases of domestic violence make it somehow artificial, even deleterious, to require an immediacy to the risk. Consecutive cycles of domestic violence, often with an increase in frequency, intensity, and danger over time, are frequently observed patterns in that context. The explanatory report to Article 52 of the Istanbul Convention clarifies that the term immediate danger in that provision refers to any situation of domestic violence in which harm is imminent or has already materialized and that is likely to happen again. Based on what is known today about the dynamics of domestic violence, the perpetrator's behavior may become predictable in situations of clear escalation of such violence. Indeed, a perpetrator with a record of domestic violence poses a significant risk of further and possibly deadly violence. This means that special diligence is required from the authorities when dealing with cases of domestic violence. They have to take duly into account this general knowledge of domestic violence when they assess the risk of a further escalation of violence and take an immediate response to allegations of domestic violence. This falls under CDU jurisdiction. The Court's case law reiterates that an examination of the state's compliance with its duty under Article 2 must include an analysis of the adequacy of the assessment of risk conducted by the domestic authorities. According to the Catalogue of Positive Obligation held in Court versus Austria, an immediate response to allegations of domestic violence is required from the authorities. The authorities must establish whether there exists a real and immediate risk to the life of one or more identified victims of domestic violence by carrying out an autonomous, proactive, and comprehensive risk assessment. The reality and immediacy of the risk must be assessed taking due account of the particular context of domestic violence cases. If the outcome of the risk assessment is that there is a real and immediate risk to life, the authority's obligation to take preventive operational measures is triggered. Such measures are intended to avoid a dangerous situation as quickly as possible and must be adequate and proportionate to the level of the risk assessed. Thus, an examination of the state's compliance with its duty under Article 2 must comprise an analysis of both the adequacy of the assessment of risk conducted by the domestic authorities and, where a relevant risk triggering the duty to act was or ought to have been identified, the adequacy of the preventive measures taken. Where it has found that the authorities failed to act promptly after receiving a complaint of domestic violence, it has held that this failure to act deprived such complaint of any effectiveness, creating a situation of impunity conducive to the recurrence of acts of violence. We must notice that, according to the jurisprudence of the Court, the terms autonomous and proactive refer to the requirement for the authorities not to rely solely on the victim's perception of the risk, but to complement it by their own assessment. Indeed, owing to the exceptional psychological situation in which victims of domestic violence find themselves, there is a duty on the part of the authorities examining the case to ask relevant questions in order to obtain all the relevant information, including from other state agencies, rather than relying on the victim to give all the relevant details. In this, the Court did not accord a decisive weight to the victim's own perception of risk of domestic violence. For instance, the withdrawing of the complaint, the changing of statements denying past violence, and the return of the victim to the perpetrator. In opus, the Court noted in particular that once the situation has been brought to their attention, the national authorities cannot rely on the victim's attitude for their failure to take adequate measures which could prevent the likelihood of an aggressor carrying out his threats against the physical integrity of the victim. Any risk assessment or decision on the measures to be taken must therefore not depend on the victim's statements alone. In ELaN judgment, the Italian government defended itself in front of the Court, arguing that the applicant withdrew the complaints and that she didn't oppose to the dismissal of the proceeding, thus causing the termination of the criminal proceedings against MP. They further submitted that the applicant had also not availed herself of the protection afforded by asking civil preventive measures. According to the government, given that Ms. Landi had withdrawn her complaints and had decided to continue to live with MP, the authorities had not known and could not have known that the applicant and their son's lives were at risk, as there had been no tangible evidence that their lives were in imminent danger. Therefore, the public prosecutor's office had not acted unlawfully or culpably. The Court rejected this argument, stating that the authorities would have adopted all the protective measures under Italian legislation, whether or not there had been a complaint or any change in the victim's perception of the risk. Indeed, the authorities had failed to consider the specific context of domestic violence, as would have been required under the above-mentioned course lane of case law. We must underline that it's precisely the context of domestic violence that makes it unacceptable to blame the victim for hesitating to take action. Women in violent relationships often show ambivalent behavior toward the offender, emotional attachment, the hope for change, but particularly the ongoing fear could all be reason for this ambivalence, which have an effect on women's attitude concerning the criminal prosecution of the offender. Being late in filing a report is one possible consequence. Previous reports indicate that women typically search protection orders after serious levels of victimization and after abuse over a significant length of time. In other words, any complaint of domestic violence are usually filed after several episodes of violence and often following a very violent incident, which renders the continuation of the relationship unsustainable, intolerable, or even potentially lethal for the victim. Factors such as financial dependency, migrant status, disability, and age could compound the abuse and impact the victim's ability to break away from the cycle of violence. This in turn means that special requirements are imposed on the law enforcement authorities when dealing with victims of domestic violence. Moreover, the assessment of risk and identification of safety measures should be conducted continuously and during all the phases of the procedure by police officers, prosecutors, and judges, from the first meeting with the victim all the way to a possible sentence, as the risk will change and new information might need to be taken into account. If risk management is not reliable and ongoing, victims may be lulled into a false sense of security, exposing them to greater risk. Crucially, any risk assessment have to address systematically the risk not only for the women concerned, but also for their children. Thus, the responsibility for taking the appropriate operational measures should not be shifted from the authorities to the victim. After having rejected the government defense, the court noted that the national authorities had failed in their duty to conduct an immediate and proactive assessment of the risk of the recurrence of the violent acts committed against Miss Landi and their children, and to adopt operational and preventive measures to mitigate the risk and to protect those concerned, as well as to ensure peace contact. The public prosecutors, in particular, had remained passive facing the serious risk of ill treatment of Miss Landi, and their inaction had enabled the applicant's partner to continue to threaten, harass, and attack her unhindered and with impunity. Whether Carabinieri carried out an independent, proactive, and comprehensive risk assessment, independently of the applicant's complaint and with the due regard of the particular context of domestic violence cases, seeking, in light of the alleged existence of a real and immediate risk to the life of the applicant and their children, preventive measures, the prosecutors, whose task was to assess this proposal, did not show the particular diligence required in their immediate response to the applicant's allegation of domestic violence. The court held that the national authorities had known or should have known the real and imminent risk of Miss Landi's and their children's lives. They should therefore have assessed the risk of further violence and taken appropriate and adequate action to protect the applicant and their children. However, they had failed in that obligation, as they had reacted neither immediately, as required in cases of domestic violence, nor at any other time. The court held that, relying on the information known to the authorities at the material time, to the effect that there was a real and imminent risk of further violence against Miss Landi and their children, in the light of the allegation of escalating domestic violence submitted by the applicant and in view of NP's mental health issues, the authorities had failed to show the requisite diligence. They had not conducted a lethality risk assessment specifically designed for domestic violence, and in particular for the situation faced by the applicant and their children, which would have justified the practical preventive measures to protect them from such a risk. In blatant disregard, these are the word of the court, in blatant disregard of the wide range of protective measures directly available to them, the authorities, which could have implemented protective measures by alerting the social and psychological services and places Miss Landi and her children in a women's refuge, had shown little diligence in preventing the violence against the applicant and her children, which had led to the attempted murder of the applicant and the actual murder of her son, M. In those circumstances, the court concludes that the authorities cannot be considered to have displayed due diligence. They therefore failed in their positive obligation to protect the right to life of the applicant and her son with the meaning of Article 2 of the Convention. By my experience in dealing with domestic violence cases, I can say that it's fundamental for the authorities dealing with victims of domestic violence to receive regular training and awareness casing, particularly respect of risk assessment tools, in order to understand the dynamics of domestic violence, thus enable them to better assess and evaluate an existing risk, respond appropriately, and ensure prompt protection. Grevio submitted that the legal system in place should afford law enforcement officials clear guidelines and criteria governing action and intervention in sensitive situations, such as in domestic violence cases. In line with Article 15 of the Istanbul Convention, such training could significantly improve the understanding of the dynamics of domestic violence, as well as its links with harm to children. The use of standardized checklists, which indicate specific risk factors and have been developed on the basis of sound criminological research and best practices in domestic violence cases, can contribute to the comprehensiveness of the authorities' risk assessment. In particular, as to concern Italy, I want to underline that in Landi proceeding, the government further contended that the applicant had failed to exhaust the domestic remedies, since she has never lodged a complaint with the Italian jurisdiction alleging a violation of her rights. The court recalls that in its report on Italy, Grevio urged the Italian authorities to fill the legislative void concerning the absence of effective civil remedies against any state authority failing in its duty to take the necessary preventive or protective measures in matters of domestic violence. In these circumstances, the court considers that the applicant did not have a civil remedy to pursue in order to assert the state's failure to act. According to its well-established case law, when no domestic remedies is available, the 6-month period to submit the application, 4 months nowadays, runs from the date of the act complained of. This being so, the court notes that the applicant had submitted her application within 6 months of the killing of her son, which even may be considered as the time that she became aware of the ineffectiveness of the remedies in domestic law as a result of the authorities' failure to stop NP committing further violence. This means, as to concern Italy, that in the very moment in which a murder or another fact of violence happens, the victim can lodge an application against the Italian state with the CDU. Of course, only if the Italian authorities have failed their duty to protect her. Finally, I have to say that on the 13th of May 2019, when taking his own determination on the ultimate proceeding open against NP, as already said, the public prosecutor asked the trial for the murder of M and the attempted murder of Miss Landi and her daughter. On the other hand, the public prosecutor asked the judge to dismiss once again the proceeding for treatment. We, the defendant of Miss Landi, made an opposition to the dismissal request, and on the 21st of October 2021, a hearing was held before the judge for preliminary investigations in order to decide whether or not to go on with the proceeding. The judge reserved this decision. In the meanwhile, the government was warned of the existence of a proceeding before the CDU. Landi judgment was published on the 7th of April 2022, and on the 28th of April, the judge for preliminary investigation immediately ordered the public prosecutor to carry on forcefully the charges against NP and to ask for the trial. On the 14th of September 2022, the very day of the 4th anniversary of M's death, Finally, the trial against MP on charges of domestic violence has been commenced. Thus, I may close my relation with the words "to be continued." Finally, I want to report to you the words of Miss Landi after she knew the court's decision. For me, it's too late, but I hope that this decision will protect other women from what I had to suffer. Thank you for your attention.
Get assessment, risk assessment. And it is so difficult because actually we have not a special, any special provision dedicated to this specific risk assessment so that judicial authorities simply follow the ordinary rules. Not having the tools and not having in mind the peculiarities, the specificities of domestic violence and violence against women. And the court is asking for an autonomous, proactive, and comprehensive risk assessment that must not depend on the victim's statement alone, and is asking that this risk assessment is not conducted just once at the beginning of a proceeding, but should be conducted continuously during the proceeding. And I think that who has some experience with criminal justice can easily detect how far from the courtrooms, daily routines is the structure, such a rich, complex structure of a risk assessment required by the European Court. So maybe guidelines, criteria, and specific tools are needed beside, as you pointed out, a specific training of our judiciary. And now I'm happy to introduce our next speaker, which is Aleksandra Ivankovic. Sorry, but I have a lot of problems with stresses in Italian as well, so much more in English. Is Ivankovic, is it correct? Okay. Aleksandra is Deputy Director of Victim Support Europe, European Network of Victim Support Services, and she has a privileged angle to help us in identifying the best way to accompany the victim of violence toward a full access to justice. Indeed, if every victim... Okay.
The test was already opened.
Ah, yes, here it is. Yes.
We share the screen.
Yeah, maybe we should before
Sorry,
anything
just a
else.
moment.
Yeah, I was just trying to put it up.
No, it wasn't. Sure.
Okay, excellent. If every victim has his own needs, victims of gendered violence due to its social cultural roots may have difficulties on the one hand in recognizing the violence they suffer, and on the other hand in cutting and exit from the cycle of violence, since it is deeply connected with a relationship with the offender. Moreover, victims of gender-based violence are more exposed to secondary victimization, victim blaming, and leaving the judicial experience as a highly traumatizing one. Therefore, it can be said that the decision to report violence and the experience of the case of Roberta Rossi just confirmed it. The decision to report violence to the authorities and to face criminal trial is a very challenging one. And specific support, careful listening, and a safe environment must be assured. In such a context, what is the role of victim support services and how can they help victims to have access to justice and obtain justice without facing too heavy consequences from the judicial experience? Considering the manifold nature of gender-based violence, which is declined in many different forms, domestic violence, intimate partner violence, online violence, street violence, some forms of street violence, like some forms of rape, violence against women, hate speeches, and hate crimes against the LGBTQ community. Each of these can be perpetrated as physical violence, psychological violence, sexual violence, economic violence. How can the victim support service be ready for offering highly qualified assistance, support to victims who have so different experience of violence and so different needs? Since the Directive 29 of 2012 requires special support services for some types of gendered violence, and thinking about sexual abuse and rape, how should these be prepared and equipped to respond to the specific task required in supporting such victims? And so I do thank Aleksandra Ivankovic for the valuable knowledge she will give us, offering an expert look at the European landscape in terms of assistance to victims and to victims of gender-based violence. Thanks, Aleksandra. If you want to stand up, and I can
But I
turn
think I
the.
need the computer because the participants will
Okay.
not hear me, so I just prefer to stand, but I think it will reach. Yeah, that should be fine. Yeah, hear me. So thank you very much for this introduction, and thank you also for inviting me, for giving me this platform. I was spending a lot of time thinking about how to approach this presentation, understanding the breadth of your project, and understanding the question of access to justice for victims of gender-based violence, and then looking into the broad scope. And having heard the interventions of previous speakers, I hope I hit the right tone, because I want to take a sort of personal/professional approach to this. But before I move on, let me first tell you something about the organization I represent. So I'm Aleksandra Ivankovic, Deputy Director of Victim Support Europe. I myself am a lawyer. No one's perfect, obviously not in this room, a human rights lawyer. I practiced at the European Court of Human Rights. I worked for a number of years as a member of the registry in the European Court of Human Rights. And in the past almost 6 years, I've been Deputy Director of Victim Support Europe. Victim Support Europe is an international umbrella NGO, non-governmental organization with membership. Most of our members, more than 70 members, are European organizations, but there is a number of organizations that are either in other international networks or organizations that are not based in Europe. Our members employ more than 5,000 staff members, work with more than 20,000 volunteers, and support more than 2 million victims of crimes every year. And we have been working on the draft of the EU Victims' Rights Directive, the 2012 Victims' Rights Directive. We're now working intensively with the European Commission on the draft of the Violence Against Women Directive. So we are there at the heart of the European policies, while our members are at the heart of providing support to victims, all victims of all crime. We are a generalist organization. We provide support to all victims of all crime, but I will talk about that a little bit later. What I wanted to address before I talk about support is the breadth of violations of rights of victims of crime, victims of gender-based violence. And how I wanted to do that is actually from a personal perspective. So I'm going to tell you about what happened to me. So I told you who I am. I'm an educated woman. I'm a human rights lawyer. I worked at the European Court of Human Rights. I know the system inside out, and this is my story. So in 2007, my ex-husband hit me the first and the last time. And it was in the middle of the night. It was in the road, in the middle of the mountains. It was December, there was snow. Children were screaming. He hit me just in the leg, broke my glasses, and I said, that's it, I'm leaving. You know, like every self-aware, informed feminist, I said, that's it, you did this once, I'm not doing. So we separated. And a few months later, I got an offer to go and work in Strasbourg at the European Court of Human Rights. So that was the perfect opportunity for me to go and do my children to France to start a new life. So we moved to France and I filed for divorce. We were separated already, but I filed for divorce. We were still legally married. It took until 2010, so it took a year and a half. I filed for divorce like towards the end of 2008. We got divorced in 2010. And the divorce, like in most legal proceedings, there were several pronouncements of the judgment. There was one that the marriage is divorced. There was another one that the children are being given to my custody, and there was one that was determining maintenance. And so I wasn't happy with the maintenance decision, so I filed an appeal against the maintenance decision. The first two parts of the judgment became final, but the maintenance decision was pending on appeal. In 2011, we were already divorced. I had a new relationship. My children told their dad about that relationship. It was hell because he wasn't happy I was with someone else. So he created this public scene. He never hurt me. He never did anything, but he created this scene. I never reported any of these things to the police because, well, who would take me seriously? He didn't hurt me. I wasn't bleeding. I wasn't broken. There was nothing to report. I just go to the police. I know the system inside out. I already work in the European Court. I see all the cases like the unfortunate Landi case where you don't want to escalate things. So you say, I'm not going to report. I'm just going to move on. I'm just going to de-escalate. I'm just going to calm him down. I want to go back to France with my children. I don't want my children to stay here with him. He can just take their passports, leave them here. I will never be able to leave. So I assume and I move on and I just calm him down and we move on. In 2012, I'm moving from France to a new country. So the things start all over again. We are divorced. The things are still on appeal for the maintenance. And then what happens is that I file for residence permit in this new country. And then the authorities tell me, you need to prove that you are divorced and that the children are in your custody. And I show them the judgment. And they tell me, but this judgment is not final. And I say, but yes, it is. And they tell me, bring the proof that the judgment is final. I go to the court to give me the clause of finality. Or not I, my mom goes. I ask my mom to go. She goes and then she calls me like 5 minutes later to tell me that she went to the court and they told her that they will not give me the clause of finality because the judge herself, a woman who was in charge of my case, told my mother, tell your daughter, ma'am, to withdraw her appeal and I will give her this clause of finality. So I'm in a pickle because I'm moving to another country. I don't have time to litigate. I know how to litigate these things, but I don't have time to litigate. I need to move in a few months. So I say, okay, fine, I'm going to do that. So I withdrew the appeal. And so I was left with very minor amount of maintenance. So this is what happened in 2013. In 2015, because now I officially withdrew my appeal, and so now finally my judgment was final. So I had this clause of finality. So I said, okay, because I had two names. I also had his name to my name. So I want to be back to my old self. I'm going to claim my original identity back. And so I go and I file for like return of just my maiden name, just to remove his name from my name. The thing is that I was born in one part of my country, in one jurisdiction. I was married in the other jurisdiction. So in one jurisdiction, they decided to accept my request for removal of the name. In the other jurisdiction, they refused because I was too late. I was supposed to do that 6 months after my original divorce judgment. And so what happened, one part accepted, the other part refused. I filed for a renewal of the passport. I live abroad with my children. My renewal of passport was rejected. So what do I do now? My passport is expiring. I can't resolve this. I can start to litigate. I can file a complaint, but I don't have time. I live abroad with my children. I need to travel. So I appeal on the one hand. On the other hand, I file for identity change to see whichever comes first, because for me, it needs to be quick. So luckily for me, I managed to resolve the identity change. So I had to change my identity. I even had a line in the form that asked me, what name do you want to have? So I could have been Gloria Vanderbilt for all that they cared, but I remained myself. So in 2016, so all of this time, since 2008, when we moved to France and then to Hungary and then to Belgium, because my children were very small and I had no power. I knew what I was supposed to do, but I couldn't do any of those things because he could always file to keep the children. He could just like keep their passports and not let me go. And so I always had to be lenient. I always had to give in. I always had to accept whatever was the verbal, emotional, financial, whatever abuse, psychological. I had to assume it because I had no power. I had to protect my children. So in 2016, when my son turned 12 and my daughter was turning 14, they were spending time with him and there was this very bad violent outburst against children. And this is when I said, okay, that's it. Because we also came to the very important point in my life. Children were 12. They had to be consulted for any decision on custody. Before they were both 12, the court could have kept my son. He could have kept my son. But once he turned 12, I could start fighting back. So I had to wait. He was 3.5. I had to wait for almost 8 years to be able to fight back. So this is the point where I say, okay, you're not going to go there anymore. And that was only lucky because the judge, and that was one of the parts of the decision that I was disputing when she forced me to file the appeal, because she never actually wanted to set up the schedule for visitation. And I wanted to do that, to have that security, but she never wanted to do that. So that was actually played well for me because there was no court order to tell me when I had to take the children. So I said, my children are staying with me in Belgium. If you want to come and see them, come to Belgium. I'm not taking. He stopped calling. Around that time, I also found out that back in 2008, even before when I filed for divorce, he sold part of our property that was in both our names. He lied to the notary and he managed to sell the property. So this is when I filed civil and enforcement proceedings. Because I haven't been given maintenance since 2008. So I filed for enforcement proceedings for maintenance, and I also filed for civil proceedings for the damages that were caused to me by selling the property that I haven't authorized to be sold. And then this is when he files criminal case against me for child abduction, because he hasn't seen children, even though he never asked to see them, but he files criminal case against me for child abduction. Apparently, there was an Europol warrant on with my name on it because they couldn't find me. So I hear about this criminal case because my mother was summoned to make a statement as a witness, and this is how I hear that there was a criminal case against me. I volunteered to go to the prosecution to make a statement in my capacity as the accused. And so you would imagine, I assume that in every legal system, if a prosecutor is interviewing someone and then hearing about criminal charges, crimes that were committed in any context, their legal obligations to take note of that and to investigate, right? So I'm giving statement to this prosecutor, who is apparently specialized in cases of domestic violence. So she is apparently trained to work with in these cases. And so I'm talking to her and I tell her, you know, I haven't been paid maintenance since 2008. She tells me, that's not why you're here. I want to know about this child. And then I tell her about violence against myself. And then she says, no, that's not why you're here. This is not why I want to talk to you. I want to know about this child abduction charge. Then I tell her about the sold property, which is also a crime. And again, the same answer. I tell her about violence against children, and the same answer. So I lay down at her feet at least 5 or 6 crimes that were committed against me as a victim. And she's pushing that aside because my ex had tough lawyers. and she didn't want to have trouble with his lawyers. And she was really just focused on resolving his child abduction charge because she had his lawyers living at her behind her name. And so it went on, and I was obviously getting frustrated because I know what's going on here, and I know that I'm not being treated fairly or justly. I don't have access to justice here. And then she tells me, but you know, I understand you. I met him. I see that you have difficult time, and I really want to help you. So this is what I suggest. Why don't we sign a deal where you agree to inform him regularly about what his children do? And this is the point where I almost threw a chair at her head. And I tell the prosecutor, this experienced, trained prosecutor who's dealing with those kinds of cases, don't you understand who the victim here is? I am the victim here. Do you understand that you are wanting to force me as a victim to sign a deal with my offender to submit to him regular reports so that you can close the case? And this is where she becomes very, that's not what I meant. Don't imply that to me, blah, blah, blah. And then I tell her, look, I'm leaving to Belgium tomorrow. If you want to arrest me, now is your chance. You won't see me after tomorrow. So she decided to dismiss criminal case against me because obviously it was a bogus case. But also the next day before I go back to Belgium, I spent the night writing a criminal complaint in which I explained what actually happened to me to make sure that it's actually on record, because that was never part of the official record that that particular prosecutor made on that day. So this is what happens in 2018. And then in 2019, because see, back in 2017, I filed for enforcement of child maintenance. My children haven't been maintained since 2007 by their father, so 10 years. And so I filed a constitutional complaint saying this is an enforcement case. There is this European court jurisprudence that after 15 months of non-enforcement, it becomes a matter of of violation of Article 6.1 of the European Convention. So after 15 months, I filed a constitutional complaint. And then while the constitutional complaint is pending, there is the first hearing in my civil case for these damages for property back in 2008. So I get to see him in the courtroom because you see, the protections for victims are only valid in criminal proceedings. In civil proceedings, we are just two parties. I claim something and he claims that whatever I claim is or is not founded. So I see him, we meet each other in the corridor. He behaves threateningly to me, but there's no one there to testify to it, and he's not being physically violent, but he is threatening me and telling me I took my children away, who is a woman, etc. So anyway, that's what happened. And it also happened that my enforcement request was rejected because the court set my enforcement claim as a percentage of his income. And because I didn't prove the level of his income, I didn't specify my enforcement request, so they rejected my claim. And I'm not a public authority. I have no way to prove his income. That's the job of the court, and I have the court to prove that, and then the court rejects my enforcement. So I file an appeal against it. I win at the second instance and goes back to the first instance. And in 2021, Constitutional Court also accepted my complaint for the length of proceedings. So I was paid around €1,000 in damages by the state budget for the length of proceedings, while my enforcement proceedings are still ongoing. In 2021, yes, in 2021, I went to be heard in my capacity as a victim now. So like that criminal complaint that I filed in 2018, they called me to make a statement in 2021 in my capacity as a victim, where I was informed that the charges for family violence were out of statute of limitations. They will not prosecute that. I was also told that if I want to go on with the claim for the violence against children, then the children will have to be heard in front of their father as the accused. And I was strongly encouraged by the prosecutor not to pursue. I consulted my children and I withdrew my case. So 2022 now, It will be 14 years, no, 15 years this December since he hit me. And in 15 or 14 years since I filed for divorce, I've never received maintenance. I've never received any compensation. I haven't received any enforcement of my maintenance, and there's been no criminal charges. So where's justice? I went to criminal, civil, enforcement, administrative, constitutional court proceedings. I am a strong, empowered, educated woman of means. Where's justice? Where's justice? I was doing that to make sure that my children are not the children in the Landi case, that I'm not the Mrs. Landi. This is what I was doing. And so where's justice? Am I a victim? I am. Of what? Of psychological, economical, verbal, physical, and also institutional violence. So this is what we're talking about. When we're talking about violence, gender-based violence, we can't be focused only on criminal proceedings. We can't be focused only on civil or on administrative proceedings. We have to look at the institutions. We have to understand how our institutions, how our systems are set up to make sure that victims can find justice. And so that is our problem, or our problems. That the system is set up so that there is no equality. We have doctrine of the European Court of Human Rights that talks about equality of arms. Equality of arms between what? Between the offender and the state. The victim is not at all in that system. We have a possibility to potentially find the back door to protect victims through the means of the European Convention, unfortunately, when their children die or when they are exposed to human trafficking. European Convention has two full articles talking about rights of the offenders, Article 5, Article 6, and a total of 0 articles protecting victims of crimes. So, how do we solve this problem? What we work on in Victim Support Europe and in our member organizations is we are trying to enforce the rights of victims. And a good start is the EU directive on the rights of victims of crime. It's only a start. We are working to amend it because we understood that it's not really working for victims. But the more we work on it, the better we get. So we implement victims' rights. And then once we start implementing victims' rights, we're talking a lot about the individual risk assessment. Individual risk assessment is already in the Victims' Rights Directive. There's also needs assessment for protection from retaliation, retribution, intimidation, and secondary victimization. So every victim of crime in Italy should have been evaluated for risk, for protection against these four things. And when we factor in that secondary victimization is also part of it, then you understand that had that been implemented properly, the Landi case and all the other Landi cases would not have happened because someone would have implemented their rights. And then when we implement these rights, we obviously have less secondary victimization. So people start trusting the institutions more. People start reporting more because they know that they will be protected, that their rights will be respected. And then as they do that, there's better evidence because supported victims whose rights are respected, provide better statements. And then there's better evidence in the proceedings. And when there's better evidence, there's better outcomes of criminal proceedings. And with better outcomes of criminal proceedings, there's better implementation of victims' rights, there's better support, there's less secondary victimization. And so we get to this snowball effect where we get to the point where we want to be, where initially you shouldn't be a victim, but then if you are, then immediately your rights are respected. What we have now, the system that we have now is that there is so much consequence for failing to respect the rights of the offender. And there is zero consequence for failing to respect the rights of the victim. So how do we get there? Easy peasy. Let me explain. So what we see as Victim Support Europe, and we've been working on this for quite a long time, is that systemic failures require systemic changes. Systemic problems require systemic solutions. So what we see is a system of victim victim-centric justice, victim-sensitive justice, where victim is in the center. And then everything builds around the victim. So every victim, and I'm sorry about the resolution, I will send you the slides and then you'll be able to see it. Every victim has 5 basic needs. So the pentagon that surrounds the victim is their 5 basic needs: respect and recognition, support and information, access to justice, protection, and compensation and restoration. Those are the 5 basic needs of victims, and as such, they're recognized in the Victims' Rights Directive. And the system needs to be built around these 5 needs to respond to these 5 needs. Every victim has these needs in different levels, in different forms, but every victim of crime will have some form of these 5 needs. Usually, the response to victims' needs comes from their social support network. So the first line of defense is victims' families, the victims' friends, their community. This is kind of where most of us will find our first responders. So for example, I, as I was going through all of these things, usually would go first to my family and friends, and then when I get stuck, I would go to a lawyer, or I would go to a psychologist, or I would call an NGO to help me out with a problem. But usually 95% of the time, it was my immediate circle that was supporting me. But then it's not enough. We can't just rely on the society, on victims' immediate circles to do the job of a systemic change and a systemic support. So what we need to have is also a broad system of generic support. And when I say generic, that's the support that's available for all victims of all crimes, regardless of who the victim is, what the crime is about, that has to have national presence, and it has to be free of charge and accessible to all victims. So some countries, and that's actually also an obligation under Article 8 of the Victims' Rights Directive. And some EU member states are doing better, some less good, like Italy, I'm afraid to say, but there is some movement in Italy, so there's hope. And the role of these organizations is something like when you go to your GP. So sometimes your GP can help you out with your health issues when you're coughing or you need a prescription, but then when there's something more complicated, then you will be forwarded to a specialist service. Yes?
Scusa, non ti posso ascoltare, ma devo uscire.
Perché?
Devo andare a continuare la popis.
Ah,
L'ho appena fatto.
è vero. Ah, però penso tanto solo consegnarla.
But sometimes this generic service will not be enough, and then this is where you need specialist services. So going back to the needs of victims, we see these needs as a pyramid. So all victims of all crimes have these 5 basic needs that I said. But then when we're organizing specialist support and when we're organizing support to victims, we need to factor in needs of different groups of victims. So victims of terrorism, for example, have specific needs for recognition. So you have memorials, you have medals, you have national pensions for victims of terrorism. Children victims, there's a lot of talk in the Victims' Rights Directive about children victims and about the need to protect them and in very specific ways and provide them specific services. And then for victims of gender-based violence, there's a need for specific services for those kinds of victims. And it's really difficult to give a prescription. I can't give a prescription about what type of services should be there for any type of victim. It really depends on, first of all, on what the crime situation is in the country. So if there is no sexual crime, though I don't think there is such a country, but if there is no sexual violence, then you don't need rape crisis centers. If there is no domestic violence, you don't need shelters. If there is no hate crime, you don't need to have specific supports, hate crime, for example, against LGBTI population, then you have to have legal aid, you have to have all sorts of support mechanisms. So it really depends. And then gender-based violence, it's a spectrum. So like, it's not just about domestic violence. It's not just about violence against women, even though that's like the biggest part of gender-based violence, but it's also about violence against trans persons, intersex persons, violence against men. because they are men. That's also gender-based violence. So for all these kinds of situations, we have to have a rather complex, flexible, and very responsive system of support services to be able to capture all these victims and to provide them the services that they need. Then the next element that we need to work with our justice and law enforcement. They need to understand what victimization is, and they need to be in a position to respond to victimization. Because as long as we just keep these two separate worlds, and one is the world of NGOs and services, and the other one is world of law enforcement and judiciary, it's not going to work. So the law enforcement and judiciary, they also need to understand problems with victimization. They need to be able to engage with victims. They need to be able to not commit secondary victimization. They need to be able to know where support services are and to refer victims to support services routinely and not just exceptionally. And this is really a huge challenge. And of course, also changing cultures, changing legislation, changing our procedures, making sure that there is no super rigid interpretation of legislation, but that, you know, there is some humanity in it as well, and not just the letter and the law and the toga and the hammer and I said so. There is a need to work also with private sector. So with insurance companies who end up quite often dealing with cases of victimization because they need to respond to an insurance claim, but also with companies as employers where crimes happen, and also as employers where victims come every day, to have sensitive approaches to understand what a victim of domestic violence or sexual violence is facing outside of work. And that's in their interest because supported victims are much more productive. And then last but not least, we need to work with what we call societal services. Istanbul Convention recognizes that as general services, but we call them societal. It's a semantics. Social care, education, healthcare. So all these services that are available for everyone to be sensitive, to understand, to be able to recognize signs of victimization, because not every victim, a very small proportion of victims will actually go to report the crime to the police or will go to seek support services. But I'm pretty sure that more than 95% of victims will go to a GP in the span of a couple of years, especially related to problems related to their victimization. But doctors, even when they know how to recognize signs of victimization, don't know what to do. So we have a lot to do working with health sector to make sure that they have the understanding of victimization and the tools to make sure that victims go to support services or to the police, whatever their preference is, but that they are also able to engage with victims. Education, teachers, support workers, technical workers, administrative workers at school, they have an enormous power to engage with victims and to make sure that victims actually reach out to support and go and report crimes. And this is what we need to do. We need to work on all of these levels to make sure that there is an element of understanding of victimization, to make sure that everyone's gone through a first psychological aid course, to make sure that everyone's gone through a course of empathic communication, that most law enforcement officials and anyone who's engaging with victims has gone through a course on trauma-informed care and trauma-informed interviews, because these things make a difference. And then what we also need to do is, especially when we're talking about support services, is to have a variety of means how support is provided. So it's not just going to someone's office and talking to someone. It's also calling a helpline. It's also having service come to your house or having service come to a library to meet you there at the neutral territory because you don't want to be seen with a support worker, of providing mobile apps, chat service, or any other way of benefit from the technologies that are available. And then there is a number of other things like the state supervision, monitoring, coordination, providing funding for these kinds of services, but also a number of standards for quality of services that I will not go into because it's like another 45 minutes of speech. So this is really briefly the picture of what we see as the national structure, national framework for victim support. And then going back to services and these generic and specialist services, it's really important to address these issues, to be clear about what they are. So Istanbul Convention talks, I think it's Article 22, 21 or 22, talks about general services, which is, as I said, which we consider to be these societal services, healthcare, education, social care, etc. But then Istanbul Convention talks about specialist services and then specialist women's services. So these specialist services in the word of Istanbul Convention is what we consider, and the Victims' Rights Directive also considers to be generalist services. So those are these services that are available for all victims of all crimes, regardless of who the victim is or regardless of what crime they've suffered. Specialist services are specialist, in particular, specialist women's services are feminist services run by women for women victims of gender-based violence. So what you can see here is sort of dissonance, because if services are run by women for women, it leaves all the other genders outside of services. So that's why it's important to have generalist services to capture all those who are different genders, because obviously gender is a spectrum. In the end, in both generalist and specialist services, most staff is with victims. So if you come to Victim Support Europe conference, you will see that 95% attendance is women. Women work there, women run these organizations, women sit in boards of these organizations, they volunteer for these organizations. So it's just how our gender society is set up, that most professions that require care and empathy employ women. Whereas women-led services are specifically, so generalist services are just for everyone, and then it just happens that it's run by women. Women's services are obviously run by feminists and are run by women only deliberately, and they can employ some technical staff men, but usually they don't employ men to work in support. They don't employ men psychologists, they don't employ men social workers, etc. And then as a consequence of that, we obviously see gender as a spectrum, whereas the specialist services mostly see gender as women, females, women who are victims of violence against women. So they usually, as I say, kind of leave outside of their focus other victims of gender-based violence. And it's also, I mean, there is a lot of confusion. So for example, the new directive that's being in the process of negotiation at this moment at the European Union is actually directive on violence against women, because politics. The original idea was that the EU would ratify the Istanbul Convention. They couldn't get political consensus to ratify a convention that talks about gender. So then Ursula von der Leyen made a commitment to adopt legislation, EU legislation on gender-based violence. And then in the drafting process, they realized that they could never get through a legislation on gender-based violence. So it is specifically legislation on violence against women. So Istanbul Convention will still provide broader protection to victims of gender-based violence than the forthcoming EU Victims' Rights Violence Against Women Directive. And then just looking into the kind of staff that generalist and specialist services employ, generalist services employ staff who are trained to deal with all types of crimes, including gender-based violence, but to an extent. So they are not specialists in provision of gender-based violence, but they can talk to a victim of domestic violence and provide referral to a specialist support and say, look, we came where we are, you need shelter, we don't run shelters, so we're going to refer you to our colleagues who do. Whereas obviously the specialist services are then trained to work specifically with a certain type of victims, but not to be able to provide support to broader type. So that's kind of difference. I guess it's logical, but I thought maybe important to put it to my table. Sorry about that. And then what is important is that there is this symbiosis between specialist and generalist services. So, for example, we have member organizations like APAV in Portugal. They are a generalist organization. They have their services across the country. They run a helpline for victims, all victims of all crime, but they also run shelters for victims of domestic violence, and they have specialist services for children victims of child sexual abuse, and they also have special services for migrants victims of violence. So they specialize in a number of things, but there they have separate staff who are specially trained and who work in these different branches. But APAV as the organization felt that there was a need for those kinds of services, and they found a way how to put it in place within their own structures. But then there's also like the other way around, when specialist services set up generalist services. So for example, Victim Support Finland was actually set up and founded by, amongst others, a feminist women's organization, and an organization that was providing housing to homeless people, etc. Because, and even including the Finnish Lutheran Church, because these organizations realized that there was a gap, that they were providing their little specialisms, but there was no one there for a victim of robbery or just regular murder. And so that's why they said, okay, let's put our forces together and set up a general service to provide. And this is actually very timely because I'm done. Thank you very much. That's my email address. If you have more questions, then we'll have you.
And it's really important to assess the difference between a formal access to justice and an effective one, and in turning a formal access in an effective access to justice, the role of victim support services is pivotal. So I'm really thankful, Aleksandra, for your speech. And now I would like to have Tim Chapman here beside me. Excellent. Tim is just become past president.
That's true.
Is it
Last
correct?
week, yes.
It's a new past president.
Yes. Do you know who the new one is?
Patrizia
Yeah.
Patrizzi,
A strong Italian woman.
a strong Italian woman in a period where restorative justice in Italy is getting the center of the attention due to the sensitiveness of our Minister of Justice. And Tim Chapman was president of the European Forum for Restorative Justice and is called upon to introduce us to one of the trickiest topics of this panel. Speaking about access to justice, we must also ask ourselves what justice is asked by the victims of gendered violence. Indeed, there is no doubt that one of the primary needs of the victims of gendered violence and violence in close relationships is the need for protection from the risk of repeated violence. And this need can find answer only in the traditional criminal justice. But on the other hand, however, when the need for protection is reduced or is not present since the beginning, ordinary criminal justice is a hostile place for victims of gendered violence who there are exposed to the painful phenomenon of secondary victimization and that there do not find answer to their basic needs. In these cases, it is possible that victims of gendered violence seek for a different justice, a justice that aims at healing the harm, so taking care of victims, instead of a justice that aims at punishing the perpetrator, a justice that has the purpose to help people in moving on, overcoming the condition of victims, of weakness, taking back control of their lives. We are aware that the Istanbul Convention at Article 48 sets some preconditions, especially focusing on the free and full consent of the victims to enter in restorative processes, recalling some general principles of restorative justice. Hence, though this skepticism is made clear based on the convention, there is not any strong ban on using restorative justice in cases of gender violence. And the same we can say for the Italian experience. We are going to have a very important reform of both civil and criminal justice, and though in the civil proceedings, it is expressly provided a ban for mediation in family matters. No similar provisions are in the reform, are provided in the reform of criminal justice. And looking at traditional criminal justice and restorative justice, the choice seems to be a matter of conflict, contrast between safety, which is pursued in the ordinary criminal justice, and agency, which is one of the aims of restorative justice. But maybe safety and agency are not opposite results, rather being two steps on the same path. Once that safety is ensured, it is necessary to let victim overcome her fragile condition and take back control of their own choices. Can restorative justice matches with these victims' needs for a justice that is not only looking back to the crime perpetrated, but is looking further to healing? And what are the pros and the cons of restorative justice in cases of gender-based violence? I think that thanks to his great experience, both as a high-skilled lecturer, scholars, and as a practitioners and a trainer, Team Chapman is the best person to introduce us to this kind of strange couple of restorative justice and gender violence. So, Tim, I gladly give you the floor. Thank you.
Thank you very much, Valentina. As Valentina says, I just stopped being the president of the European Forum just last week, and I've been replaced by a very strong Italian woman, Patrizia. One of the reasons I think I'm here is that the European Forum set up a working group on gender-based violence, and we have a very powerful group of people, as you'd expect, mainly women. I think there are only two men, myself and another person, and Valentina is a very valued member of that working group. My particular role with three other women is to think of the criticisms of restorative justice in this area, take them very seriously, and see if we can transform restorative justice to answer those criticisms. And that's what I want to talk about today. I suppose the first question I have about myself, and maybe you have, is who am I? And in a way, in English, we would often say, like, who are you to talk about gender-based violence? You're a man. And I suppose that's the first obstacle I need to get over. I want to be a man that demonstrates solidarity with women in the area of gender-based violence. And I want to be a man that encourages other men to be accountable. I don't know if you can see this. This is a little white ribbon on my jacket. I'm not sure if the White Ribbon campaign exists in Italy, but in Britain and Ireland, it's a campaign to get especially men to show solidarity in relation to gender-based violence, to say, by wearing this, we do not accept this behavior and we will challenge it wherever we see it. And I think this is what interests me in this area. It's a man's problem. It's not just a woman's problem. It's a man's problem because the man causes it. And the man can choose to stop causing gender-based violence. And the world would be a safer and much more pleasant place to live in, I think, for both men and women. So that's the first thing. What knowledge do I have? I'm engaged in a piece of research that is coming to an end. I've been doing it for 4 years, and it's been about talking with victims of crime in depth about their story, about how they became a victim, what happened next, and how they found restorative justice. I have a female research assistant who helps me, and we've met I think 30 victims, and we've taken what we call a narrative approach, which is just to listen to their story, not to come with preconceived theories or preconceived questions. And 10 of those 30 have been victims of gender-based violence. Interestingly, there are, sort of echoing something that Aleksandra said, 2 men who have also been victims of sexual violence, basically. But I'm not counting them as part of the 10. There's 10 women who've been victims of. We've spoken to, and I must say, speaking to them and in my late stage of this career, and considered an expert in restorative justice, has fundamentally altered my approach to restorative justice and my thinking about justice. Valentina also mentioned that I'm a practitioner as well, and I'm engaged in 2 major projects at the moment of institutional sexual abuse. One is connected to the Catholic Church in Ireland, and the victims are men now. They were 11-year-old boys at a school when they were very brutally abused by priests. And I'm working with around 20 victims, and there has been 6 meetings between a victim and the hierarchy of the Catholic Church, 6 restorative meetings. And interestingly, I have another project, which is a Buddhist group, which is unusual, you would think, but the extent, and this is young women who have been sexually abused by the so-called gurus, Rinpoches of this Buddhist group, and some of the stories that they have told me about what happened to them and how they were used sexually under the pretext of some sort of path to enlightenment has been horrific. So that's where I'm coming from. I'll try and be quick because I know we're behind time, and I'll try and speed up. One of the things I want you to think about is what is restorative justice, and what is the image in your mind when you think of restorative justice? Because I want to challenge a sort of one idea of restorative justice. What I find in Europe is restorative justice is largely considered to be mediation. It is the predominant form of doing restorative justice, and this originates in the 1999 Council of Europe recommendation. And if your image of restorative justice is something like this, a mediator with 2 people in a room attempting to resolve a conflict, the mediator is neutral and impartial. Oops. Why is that doing that? I did it wrong. There's an aggressive man and there's a vulnerable woman. If that is your image of restorative justice in the area of gender-based violence, and if you think it's not appropriate, I would agree with you. But I don't agree that that's the only way to do restorative justice. There has been, well, basically, I think there is a view that restorative justice is mediation, and it's designed to achieve apology. And if those of you who work in domestic violence will understand, apology is a recurrent strategy that a man uses to maintain an abusive relationship. Forgiveness, again, there's a dynamic of apology and forgiveness that maintains the abusive relationship. nor is it a means of relationship reconciliation. Now, if that's your view of restorative justice and your view is it's not appropriate, then I'm on your side. But it's not my view of restorative justice at all. Incidentally, none of the women that I have interviewed went into restorative justice to gain an apology, to give forgiveness, and to reconcile their relationship. But simply they went to make a clean ending to a relationship. Since then, there's been another Council of Europe recommendation which talks about restorative justice, and it opens up the space for a more flexible, more creative, more innovative restorative response to, as Aleksandra was saying, a range of different crimes, not just gender-based violence. But I think we have not fully explored the potential within restorative justice to engage with contentious issues that relate to relationships of power, relate to trauma. But I believe it's possible. So first thing, restorative justice is not an alternative to criminal justice. I think that's another view, that if a perpetrator opts for restorative justice, it means they won't need to go through court or be punished. Most of the women who I've met who have talked to their perpetrators did so after the court case, after the perpetrator had been punished, and usually because they were serious offences, attempted murder, etc. They got long prison sentences. So what victims said, we have no problem with punishment, no problem with the person who's made my life hell being locked up for a long time. But when he got prison, I didn't feel like celebrating because my problems were not over. And that's what they say. And the meetings that they had were usually within the security of a prison, which reduces the level of risk and to their safety. So again, it's not just something that happens before a court case in order to excuse somebody from having to face judges. I want to talk a bit about sort of access. What do we mean by access to justice? And I've taken a very simplistic approach and looked at the statistics in England and Wales. Basically because they were the easiest ones for me to get. I'd be interested to hear if there are similar statistics in Italy or whatever country you may come from. And I took them in two areas. One is rape. And just very quickly, we do not know how many rapes there are every year in England. But we do know there are many, many, many more rapes than are reported to the police. We can be certain of that. A lot of women who are raped do not report to the police their experience. There are over 60,000 reported to the police, and 42% of those are withdrawn by women. Partly because the incredible delays between a report and coming to court. There was a recent case in Northern Ireland, it was 5 years from the offence to coming to court. So that horrible incident of violation has been hanging over without being resolved a woman for 5 years. So many women think it's not worth it, that the experience of going through the criminal justice system is as damaging almost as the original offence, the original suffering and injustice that was imposed on them by a man. And so they withdraw their cases. There are others that are withdrawn by the prosecution because the witness isn't good. The victim doesn't measure up. And there's been research, again in Britain, where prosecutors have a sort of assessment. They're not assessing the risk to the victim, they're assessing the risk of the victim. of the victim being able to give a strong testimony in court, particularly when they know the defense lawyers will do everything they can to undermine a victim of rape and try and make out that there was consent, or it was her fault, or she was leading them on, whatever it is. She shouldn't have been drinking, all sorts of things. They will try and undermine the victim's case, and the jury in a British system will quite often be swayed by these arguments because we live in a misogynistic society, and we have a patriarchal criminal justice system. So what that means is, if I can read this, 1.3 of the offences that are reported to the police, just over 1 in 100, actually comes to court. Some of those will be found not guilty. Even those that get to court, there's a high level of acquittals. Turning to domestic violence, again, similar patterns. We cannot estimate the amount of incidents of domestic violence that go on in Britain every day, but we do know it is many more than the ones that the police are called out to. The police are called out to a lot. It's one of the most frequent crimes that are called to. But of those, only 9% are charged that actually become official cases with the police. And of those, then 6.5% end up in court. So when we say access to justice, it raises huge questions within the formal system. You know, what is going on in that gap between those that end up in court and the huge volume of violent, abusive acts that are perpetrated on women every day? How are women coping? What's the impact on society, family life, etc.? Because they are not being attended to by the system. And the other question I have is, say tomorrow, for some magical reason, every incident of sexual harm, domestic abuse was reported to the police. Could our system cope with that? I suspect not. I don't know what Italy's like, but in Britain, the criminal justice system over the last 10 years has been cut back in terms of resources. So in a way, the system is not designed to deal with this and could not cope with it. So we need to find an alternative. And I'm not saying that restorative justice is the alternative, but I think it could be part of a different approach to gender-based violence. I think restorative justice, at its best, takes access to justice very seriously. It puts, I believe, women's choice first. And what does that mean? From my research, a lot of women have never heard of restorative justice. It doesn't even come into their mind. Funnily enough, they have a feeling inside, I need to have a conversation with the person who did this to me, whether it's an anonymous person who's inflicted a sexual crime or somebody they've lived with and used to be in love with maybe. They have a strong impulse. We need to talk about this. This is not an alternative to punishment, but in addition to punishment, we need to talk. That's what I get from the victims. They, you know, one classically was nearly killed by stabbing. The surgeon was amazed that he was able to save her life. The knife just missed her heart by less than a centimeter. And she woke up and the surgeon said, "We've saved your life, you're going to be okay." And she said, the first thing I said to the surgeon is, I need to have a conversation with him. That was just the first thing that came into my mind. I thought, what? Is that what you were thinking then? And for the next 7 years, she tried to have a conversation with the perpetrator and eventually did. So there's not enough information about what choices are open to women. There's not enough support to help them make those choices freely. We don't have a victim-friendly system, just as Aleksandra has said. I have so much evidence of how the system is incredibly unresponsive to victims. When they go to the system, to ask for support and help. We need experts with humility. This is where my training comes in. I now, under the influence of really listening to victims, particularly women, we need experts with humility and ones that respect women's authority over their own lived experience. We need experts who actually listen, which is, it's unbelievable, but it's a very unusual thing when an expert listens to a victim. And practices with a sense of curiosity. This is a unique human being who's come in to see me and has a unique story. No matter how many people I've interviewed in the past, this is something new, and shows compassion and also courage to help that woman make choices that may have an element of risk to it. We need a safe process of justice designed specifically for the individual woman to address what matters to her and to restore what she needs to participate in society, to get on with her life, to put it behind her and move on. And I was struck with Aleksandra's story about how hard it was for you to just stop that relationship and move on. It's, you know, it's never ending. I'm a great admirer of this cultural theorist, Bell Hooks. She died within the last year. An African-American woman, feminist. And she sums up what I think is a problem within criminal justice. So if you can't read it, I'll read it out for you. No need to hear your voice when I can talk about you better than you can speak about yourself. No need to hear your voice. Only tell me about your pain. I want to know your story, and then I will tell it back to you in a new way. Tell it back to you in such a way that it has become mine, my own. Rewriting you, I write myself in you. I'm still authority. I'm still the colonizer, the speaking subject, and you are now at the center of my talk. So often, I think even people who are well-meaning and want to help women steal the story from the woman and mold it into their own ideology. I think restorative justice takes violence against women very seriously. We don't address it as, has a crime been committed? Is there evidence for prosecution? Can we prove this person is guilty? Can we punish this person? We actually focus on the act itself. And one of the guiding principles I have is the person is not the problem, whether it's the victim or the perpetrator. The problem is the problem. And the problem is the harm caused by an unjust, coercive, and traumatic event. And the person who should define what that problem is the woman through their own lived experience. Quotation from Desmond Tutu. If you're neutral in situations of injustice, you've chosen the side of the oppressor. I do not believe restorative justice should be neutral about gender-based violence. Should not have a sort of indifferent attitude. We need to be on the side of the victim. That's not to say that we want to undervalue the humanity of the perpetrator. And interestingly, I'm studying a lot about trauma at the moment because of this. And there's evidence that a traumatized person finds it very difficult to deal with somebody who's been reasonable and neutral about everything. They are hyper vigilant of any threat, and they will see a sort of objective professional as a threat, as against them. And certainly my victims and in my practice, a victim really likes me to say, you have been bullied, you have been oppressed, you have been unjustly harmed. It is affirming to them, and they often say in the sort of debriefing after the process finished, that was very important to me, Tim, that you said, you put it into words. What we're interested in the European Forum is the systemic nature of the harm. It's not just one bad man and a vulnerable woman. It's part of a society that is filled with misogynistic values and beliefs. We're exploring the whole idea of rape culture Where does it come from? How does it relate to the need for men to exert coercive control? Secondary victimization is often a symptom of that those sort of values, that women are not received in a sensitive, empathetic way by the system. There are patriarchal power structures. Most of the time, we're not even aware of them. We're not even aware, and these women that I've talked to have made me aware of my unconscious bias formed from living within a patriarchal society. And just the impact on women's autonomy generally. I was very affected by this. I don't know if you followed the Sarah Everard case in London. She was kidnapped, raped, and killed by a police officer. And there was an outflowing from women on the street, on the social media. And there was one particular tweet that I saw where a woman had listed 20 things that she's never been a victim of sexual harm. But there are 20 things that she routinely does to keep herself safe. And then she'd asked her partner to list the things that he does to keep himself safe. And he just wrote none of these. And that to me was stark about the inequality between women and men. I don't think very much about my safety when I'm on the street. I suspect you have a different view, a different mentality. And that, right, it restricts women's autonomy to a terrible extent. So I think there's a possibility within good, creative restorative justice to begin to look at what I call sometimes the ecosystem that sustains abusive behavior, and to examine gender-based violence both as a private trauma but also as a public issue. And what is interesting to me that is emerging from my research is that women want people to bear witness as they move through a restorative process. You know, one woman wanted to go and tell the perpetrator, "You have not destroyed me. You tried to, but you didn't succeed." But she needed people to be there to witness that. I don't know if that makes sense to you, but that gave her a sense of reclaiming her power, not just the act, but the witness. So I think restorative justice doesn't have to be a private, secret, confidential thing. Other people can observe. It takes what matters to each person, each woman seriously, and puts their choices at the center of the process. For me, restorative justice means restoring what matters to victims, and they define what matters, not the professional. These are some of the things they've told me. A lot of them are to do with being believed that their truth is accepted, because a lot of women who are victims of domestic abuse, sexual violence, are not believed. They're made to feel ashamed, whereas it should be the perpetrator that feels ashamed. A lot of them want to reclaim their control and power. To get, so many of them said, "I got my old self back. For so many years, I wasn't myself because of the trauma of what I experienced." And they want to change the narrative from being a victim. You wouldn't believe how many women who have been victimized, traumatized, have gone through a process of restorative justice and now want to champion women. I was talking to a 20-year-old on Monday as part of my research. And she says, "I was brought up in Irish society where we didn't talk about sex. We didn't talk. I was ashamed to say that I'd been raped." She was raped when she was 14. But now I realize I shouldn't have been ashamed. I was a child being raped by a man. Why should I be ashamed of that? But I couldn't talk about it. For years, I could not talk about it. Therapy helped, but the restorative process also helped. And now she says, "If you ever want me to talk about it to other women to help them, please call me." And this is a 20-year-old. She says, "We need to talk about it. We need to stop being ashamed." Strangely enough, the participants need each other in restorative processes. This keeps doing it. I do. Maybe start doing this. Yeah. The victim's narrative of harm, as I call it, will have gaps. Will have questions, things, even though it happened to them, there are things that they don't know. And often it's only the perpetrator that can answer those questions and complete their story. Similarly, a man who's inflicted violence, abuse on a woman has no idea, I believe, of the suffering and injustice that he has caused until he hears it from the woman. So if your view is that women need to move on from a harmful thing and men need to become more accountable, one of the best ways, not the only way, best ways is for some sort of safe meeting where a woman can look the man in the eyes and say, this is what you did. This is how it impacted on me. This is what I need to know from you. This is what I want you to do. And to feel the power of that. I think restorative justice takes women's safety seriously. Here's a quotation from one of the leading experts of trauma, Gabor Mate. Safety is not the absence of threat, it's the presence of connection. And by that, I don't think he means connection with the perpetrator. It's connection with society. It's support from family, friends, society, the systems, the services that Aleksandra was talking about, the lawyers that Roberta was talking about. Safety is very critical to the restorative justice process, as Valentina was talking about. And no restorative justice process should ever take place unless the victim permits it. There should be no pressure on the victim. It must be a free choice and an informed choice. That the perpetrator admits responsibility for causing the harm. A restorative meeting cannot be a discussion about who is at fault. The perpetrator must accept that he was at fault, it was wrong, it should never have happened, and that both parties commit to a safe, respectful, and fair process. Now, that doesn't just happen by accident, it happens through hard work by the parties with the facilitator. I'm running out of time, so what I would say is I'm working on a risk assessment process that is contextual and participative. And by that, I mean that I work through the different areas of risk with the woman, and together we co-design a safe process, which may or may not be a meeting. But what I can say is the meetings are usually the most rewarding, but it doesn't have to be. So it is co-design. The woman's choices matter at every small stage. One woman at this stage, it wasn't me, thank goodness, decided she wanted to go ahead with the restorative process, but she didn't feel okay about the facilitator. So she said, I don't want you to be my facilitator. And this person was restorative, says, that's no problem, I'll find you another one. And she said that was the first time that she'd been treated as an adult woman who can make decisions and who has some power. So humility, respect, curiosity, compassion, courage, and support are the things that are necessary to engage. Risk assessment, certain questions, what are the risks of proceeding? What can be done to manage those risks at an acceptable level? But also, and this is something the victims told me, I never asked this question, what are the risks of not proceeding? Some victims say, I have been traumatized. I have gone through hell. Nothing worse can happen to me. I need to do this in order to get through it and out the other side. So that there are risks of not proceeding as well as risks of proceeding. Areas of risk, the responsibility of the perpetrator, the people's motivation, the patterns of behavior and the relationship between the victim and the perpetrator in the past, if they have a relationship, and also their capacity to participate fully in a restorative process. Some people are mentally ill, they're under the influence of addiction, they may have neurodiversity issues. So capability needs to be taken into consideration. Areas that reduce risk, the availability of support, their own resilience and courage. And one thing that really amazes me is I've met women who are incredibly vulnerable and broken, but at the same time, incredibly strong and resilient. They cannot be reduced to one thing. You are vulnerable, you are trauma. Showing huge reserves of courage. Protocols, well worked out protocols that keep people safe, and good facilitation. This is sort of, and I'll not bore you with this, this is just the sort of approach I take to design. There are many different elements of a restorative process, and within each element there is a huge variation. So there is no one restorative process. There's almost an infinite diversity of different ways that you can restore. So mediation, conferences, circles, surrogate circles, witness circles, circles of support and accountability. Back to my friend Bell Hooks. This sums up what a lot of women say to me. To have a voice, and not just any voice, but one that could be identified as belonging to me, has been so important to them. Grazie.
I'm thankful to Team Chapman because I think that most part of the, excuse me, Steve.
Sorry.
A great part of the audience is not familiar with restorative justice, and the risk of misunderstanding is always very high in this case. And I think that today we had the very right approach to the issue. So we are, the first step is a great step. Thank you, team. And I invite you in making some questions, but only short ones, because we're running out of time. Otherwise, yes, Simona Manzoni, Vice President of Radio.
Oh, right.
Because we can't hear. Thank you. I would like just to ask you, I know restorative justice more in conflict area. And you were speaking about this process and you present this as in a conflict, but in fact, when there is violence, there is violence. And I'm just asking to myself, if you are working, so if I understand, with people, with perpetrators that have passed the process to recognize that they are guilty, so they are not anymore in a violent relationship. Is it right?
Yes.
Because, for example, for Istanbul Convention and even for the feminist practice on violence against women, that is not only on domestic violence, all kind of violence against women, mediation is even forbidden by Istanbul Convention. But mediation is before that, you know, there is a process, crime, violence is a crime.
Yes.
And it's not a conflict. So I would like to understand a little bit better about this. Thank you.
It's possible I didn't make myself clear. I am critical of mediation in this field because it sees what I consider to be an oppressive, unjust act as a conflict. I've yet to meet a woman who describes being raped as a conflict, or a woman who you know, has been repeatedly abused by man as a conflict. They see it as an injustice, an act of coercion and control. They don't see it as a conflict to be resolved. They see their need is one of justice. And again, that was the sort of, for me, the theme of Aleksandra's story about herself, the difficulty that women have of getting justice. So it isn't for me a conflict, and I think in most cases mediation is inappropriate. I wouldn't count it out, but I think in most cases, I think we need to be much more creative in our processes. In relation to the perpetrator cannot enter into a restorative meeting with a victim unless he has accepted full responsibility for the harm that his criminal actions caused the victim. As I said, we cannot have the meeting between the victim and the perpetrator to become an argument about who was right, who was wrong, who's good, who's bad, who started this, who didn't. That is not restorative. If they want to have that argument, they need to go to lawyers and have that argument in a different place. So you must have perpetrator responsibility. They may not feel 100% responsible, but they need to say, yes, I did hit you. Yes, I did rape you. There's a case in Ireland where the rapist said to the woman who wanted to meet him, I'm happy to meet you. I will tell you the truth. I will answer all your questions. I will listen to what you have to say, but do not expect me to apologize. And I was shocked when I heard that. And I said, what did you think? And she said, it never struck me that that is why I'm going to meet him. I don't want an apology. And then we talked more, and I realized that if she had said to him, if you don't apologize, I will not meet you. Who has the power? He still has the power. He is still calling the shots. He's still exerting control over her. So she knew that what she wanted to do was to say to him, you do not control me. You have not, you try, this was a terrible rape, really horrible. And you try to humiliate me and degrade me and shame me, but I'm not ashamed. You should be ashamed. And that's what she wanted to tell him. But he had to say, yes, I did rape you. His story was, I raped you because I hate you. You're just the sort of woman I hate. So he was, somebody who hated women. But she was very satisfied with the meeting for her own needs. I'm not sure if that answers your question, but as far as I understand it.
Yeah. For example, there are organizations that are doing in a similar way this kind of practice, but they don't have this restorative justice. For example, I know also one from Restorative, that is from Netherlands, that when this certificate of women also goes on, because there is also an empowerment process when you give specialized services to women, just not assistance and support.
Yes.
You are trying to reinforce and struggle feeling of capacity and feeling.
Yeah.
Right? So, for example, they organize women and then speak with them, even if they decide guilty. And this is also a way to make that she speak. And she also see. So no, it's not a mediation of neutral case, but otherwise, any country will do. And this is also a way to, yes, release and make, to feel, as you say, more power, more powerful and free from an identity of the past.
Yes, yes, yes.
So, yeah. So it's I can see that there are similar process.
In France and in Spain, they have a law which is their interpretation of the Istanbul Convention that says that you can never take a place in domestic violence cases. But in France, they've developed this thing that actually I briefly showed on the PowerPoint of 3 victims of domestic abuse meeting 3 perpetrators, not their own perpetrators, because the law says you can't do that. So they meet to really share their experiences. And we've interviewed 3 victims who have gone through that process. 2 thought it was very, very good, and 1 didn't like it. So that's an example of, restorative practitioners trying to create a restorative experience for victims that empowers them, even if it is not this sort of classic mediation. Thank you.
So I think we can leave the floor for the next panel. Thanks.
Thank you.
Good afternoon, everybody. Good evening, perhaps. I regret to say that there is not much time left for a proper introduction to our speakers, to our valuable speakers. So I please ask, I refrain from, of course, from speaking and ask Chiara Angiolini if she wants briefly introduce this panel. And I ask our speakers to keep within the limits of 20 minutes. Thank you. Ciao, ciao Natalia, ciao Maria Rosaria, ciao Nuno, e ciao Chiara. Please.
Welcome to everyone. I'm sorry, I had some problems with my connection. I just wanted to thank the coordinator of the project for organizing this conference, and of course the speakers of our panel. And we are very happy to have this panel with really experts in the analysis of the intersection between family law, gender, and other field of law, as Professor Ferreira shows. So I would organize the speeches, starting with the Professor Marella speech, if Professor Marella is online. She's not in at this moment, so we can start.
No, I'm online, but I can we can follow the program anyway. But anyway, I'm here.
Okay, so if you want, we can start with you, or if you prefer not. Okay, Professor Marella is a real expert in all the intersections between family law, private law, gender, also from a critical point of view, and we are really pleased to have her speech for the starting of our panel. Please.
Thank you, Chiara. I wish to thank the organization of this conference, Chiara Angiolini and Valentina Calderai for inviting me. I'm gonna talk about interspousal torts and as an issue of gender and access to justice this evening. We face actually the crisis of interspousal immunity in torts. What it means that since few years ago, it was not possible to sue toward members of the family. So no lawsuits in tort within the family. And what was the origin of this doctrine? In common law, this was a black letter rule, and it has been abolished in different jurisdictions starting from 1962. In civil law, it has always been an unwritten principle, but it was enforced in every jurisdiction in the name of family law exceptionalism. So its decline is perceived as modernization. And in family law, modernization means women's equality and women's rights. And just to clarify what I'm going to say, I assume here that this polarization, modernity versus tradition, is a pattern under which family laws are commonly analyzed and evaluated. But according to me, it is a divide which is not free of ambiguities and contradictions. So it is possible immunity in torts equals tradition. In common law, it is the product of one of the effects of the doctrine of coverture, according to which the spouses are one person and that person is the husband. In civil law, the protection of family community prevails on individual members' rights, and this is the reason why immunity in tort was enforced. Another reason is the following: a wrongdoing on one's own spouse results in harm to the wrongdoer himself, so no legal sanction is required. This was a common assumption at the time. So the decline of immunity in torts, as I said, means the enhancement of women's equality and rights. And this is also a matter of access to justice, and access to justice as a gender issue, because plaintiffs in tort were and actually are mainly women. And so it seems that recognizing interspousal tort claims empower women. And this is something that we should scrutinize, and I will try to in the next minutes. But anyway, what is to be noticed is that nevertheless, although immunity in torts has been abolished or has been revised also in civil law, there's a resistance by the courts in both common law and civil law. Courts are reluctant to award damages to one spouse against the other to solve issues arising from family breakdown. And one of the reasons why is the protection of family law exceptionalism, and the other one, which is also crucial, is the respect of personal liberty in sexual and emotional business. But in Italian case law, there's an important overruling in 2005 when the Supreme Court, Corte di Cassazione, decide the following case. There was a wife sues her husband for divorce, for non-consummation of the marriage, and as damages for emotional distress. The problem was that the husband's sexual impotence that was not disclosed before marriage. So here, another family law remedy was possible. Of course, it was an annulment of marriage, but what the Supreme Court says is that family law is not to be conceived as a closed, all-encompassing and isolated body of rules. On the contrary, the protection of fundamental rights cuts across the whole legal system, so the family should be envisioned as the place of oneself actualization, fulfillment, rather than the site of fundamental rights setback. And so basically, damage award is recognized. The second argument deployed by the Supreme Court relies upon the ineffectiveness of family law remedies because the charge of separation responsibility displays no effects on the wealthy spouse. As to the entitlement to financial support, while succession rights are lost in any case after divorce. So we see here two motives. There's a tendency to sanction the kind of punishment of what is considered as unfair behavior, but also the idea of an attempt to redistribute family wealth. So this tendency is, I cannot dwell on cases to just because I want to say in the time that I can use, but the problem is that damages award compensation are usually very high. Anyway, what is to highlight in here is that through interspousal torts, we have access to justice for fundamental rights. So what is protected is physical integrity, dignity, health, sexual and reproductive self-determination, and so on. More recently, something is happening. There's an increase of male plaintiffs number. And here we see in case of wife's infidelity, a different meaning of dignity is at stake. Courts start talking about dignities as honor, and this resembles James Whitton's famous critique of European dignity as honor. But anyway, the question is now, is interspousal torts a way towards egalitarian family? Is that really modernization? One effect, as I said, is that damage compensation in these cases are quite high. On the other hand, as I said, it seems so damage compensation seems to compensate the modest amount owed for alimony, what enhance what is due to the weaker spouse at family breakdown. So here, comparative analysis helps to better understand what are the pros and the cons of this case law. Especially common law courts are still reluctant to award damages to one spouse against the other to solve issues arising from family breakdown. Above all, the rhetoric of fundamental rights doesn't play the same role in common law as in Italy and in Europe at large. And so to sum up, what are the pros? Protection of fundamental rights, which goes toward deeper constitutionalization of family law, redistribution of family wealth. And here's to be noticed that in American case law, some courts talk about unjust enrichment. They're very cautious in not overlap alimony with damage compensation in these cases. So at the end, what seems to be the outcome of this case law is women empowerment. According to, I would say, a specific idea of women's empowerment, and especially of a specific idea of what men and women relationships are. A famous critical theorist, Natalia, talks about governance feminism here. And the core issue is, are women victims, are to be seen as victims in this kind of patterns, at least. What are the cons? It seems to me that under the threat of tort suits and high damage award, family bonds are strengthened and personal liberty is restricted. There's an overregulation of family relation and the specter of commodification of love and affection. And at the end, a defeat of those feminism or feminists that refuse to depict women as victims. So, at the end, the impact of interspousal torts in terms of modernization is controversial. Also, from the point of view of gender equality, downsides are to be taken into account. So it seems to me this is a case for a careful scrutiny in the light of cost-benefit analysis, which doesn't mean to rely on economic efficiency. Rather, cost-benefit analysis is to be understood as this, and the analysis of distributive effects. Who wins and who loses when such a reform is enforced. So backlash in interfamilial torts suggests more great caution. The ones I have illustrated before, but also this kind of male revenge pinned upon the violation of husband honor, which witnesses the ambivalence that legal change may conceal from multiple perspectives. Thank you very much for attention.
Thank you.
Thank you.
Thank you very much. Professor Marella, for this very to the point and meaningful and yet brief, short intervention. And if Chiara, Chiara, do you want to add something and introduce perhaps our next speakers? Or
yeah, of course, with pleasure. I wanted just to ask to Professor Marella for the next for the Q&A part, if we will have one, if the notion of honor embedded in dignity in male plaintiff cases is applied also on the contrary when women are plaintiffs. And I think that this is could be a good way to show how gender play a role in judges and courts decisions. But we are really late in time, so we postponed the answer and the debate for later. And now I will give the floor to Professor Rueda, which is a close friend of mine, and she is also a professor at the civil department at Universidad Externado de Colombia, if I pronounce it well. And she is a real expert of family law and tort law in family law. And today she will address the problem of victimization by public bodies and public entities when they address the problem of violence, if I well understood her intervention, and I leave you the floor.
Thank you.
Thank you so much, Chiara, and of course, Professor Marella for her presentation. Good afternoon. I would like to thank, in the first place, Professors Electra Stradella and Valentina Calderai for this kind invitation, and of course, Chiara Angiolini and the University of Pisa, because I am extremely honored to share this panel with these extraordinary professors. I, of course, thank you, all the people attending this event. Yes, Chiara, today I would like to share some considerations about the institutional violence as a very common problem in Latin America, with the conviction that this could also occur all over the world. In order to give my presentation, I will show some general characteristics of this phenomenon in relation to the trend to decide based on stereotypes. In this regard, I will refer to some cases identified as institutional violence taken from the jurisprudence in some countries in Latin America, and of course in the Inter-American Court of Human Rights. I pretend to present some remarks about the impact in human rights and international liability of the states for hampering access to justice. So the institutional violence is a phenomenon that appears when the authorities or public bodies in the exercise of their functions obstruct the realization of human rights. This problem is intensified when this hindering is based on stereotypes about the different conditions that come together to bring about the discrimination against a group or an individual. So the women is one of the groups more discriminated. There are several problems related to this. Firstly, this is a widely extended problem, and it is culturally, socially, and institutionally reinforced, normalized, and legitimized. However, at the same time, it is minimized and underestimated in relation to the huge damages that it can cause and boost. Without the intention to be exhaustive, the institutional violence can be described as all the conducts by action or omission of the state agents that constitute effective aggressions to people of discriminated groups, all in the exercise of their duties. But there is also institutional violence when they have the mandatory duty to investigate crimes and they do not comply with it, by the absence or inefficacy of the investigations and sanctions to the responsible of the crimes. Or, for example, when they adopt a decision based on discriminatory stereotypes, or if their decisions reinforce biases about a discriminated group of people. Or when they embrace interpretations that make prevail procedural rights over substantial exercise of human rights, concreting various forms of refusal of justice. Or, for example, if they do not apply a differential approach to determine the disproportionate impact of the decision in the aggravation of pre-existing vulnerabilities, materializing evident inequality. When they do not impose protection orders because of the underestimation of the facts based on prejudices about the potential victim, or if they do not value in a comprehensive way all the materials and evidence within the process, or if they do not put under scrutiny the declarations of a person because she or he belongs to an institution as a proof of credibility, as often happens, for example, with respect to the acts of members of the security forces, politicians, people in public life, among others. When they do not recognize the systematicity of the violence to value individual incidents. Related to access to justice, the criteria to identify this violence could be to determine in which occasions could exist discrimination patterns. This because they can put people in a particular position of vulnerability against the state. Thus, it is configured a relevant asymmetry that put in risk the equality. So the person is totally unable to defend herself or to exercise her rights. This could also happen if the state has a reinforced protection duty regarding a specific group of people, for example, children or people in prisons. The case of imprisonment is particularly relevant because the discrimination in the basis of judicial system could contribute to an overrepresentation of certain group of people in the system. That is the case, for example, of Black people in Brazil, according to the Inter-American Commission of Human Rights in a press release in 2018, or migrants all over the continent. But it is also the case of women in all the region, because it is demonstrated that main crime for which women enter to prison is drug micro-trafficking, in contrast to those who run criminal enterprises, who are mostly men, and they remain untouchable. This is a very good example of the need to incorporate a differential approach for the analysis of legal problems. Because women who get involved in drug crimes tend to have a specific profile that from the outset places them in positions of vulnerability that are reinforced and reproduced in a more drastic way at the time they are incarcerated. Most of them are poor women who are heads of households and who come to participate in this market by virtue of the role that has traditionally been assigned to women, as those who must take care of the children. But in addition, due to their poor economic conditions, these women must assume not only the role of care, but also the position of being providers to supply their children and the people who depend on them. These are women with few opportunities to enter the world of work in good conditions, as long as they have no educations or the jobs they can aspire to are precarious and the difficulties in finding employment are increasing. And that vulnerability is functional for drug criminal organizations, since they are women with pressing economic needs who precisely for this reason can be easily co-opted to carry out low-paying and high-risk activities, in which they can be quickly replaced if they are captured, without the dangers of the heads of the criminal organizations being identified. This phenomenon has revealed that public servants normally decide based on prejudices regarding the identity conditions of the people, and this determines a lack of seriousness in the verification of the facts. It is what Miranda Fricker describes as epistemic injustice and Christy Dodson defined as epistemic violence. Making specific reference to family relations, one of the examples in which institutional violence is more systematic is precisely related to domestic violence. In this scenario, it is common for the actions of the authorities to be mediated by different types of stereotypes. Although here the authoritarian conception of the family and couple relations assume great relevance. Thus, for example, in the jurisprudence of femicides committed by the victim's partner or ex-partner, in the vast majority of cases, there have been more than one warning signal, sometimes even with previous complaints of aggression or threats of aggression. What the jurisprudence throws up is that the authorities normally underestimate some behaviors because they consider them normal. For example, behaviors of control of the movements and communications of the victim, for which they do not order protection measures. It is also common for this to manifest itself in sexist expression, by virtue of which the victim is blamed for the situation. They are told that jealousy, even if it is expressed in coercive behaviors, is part of love relationships. There is also significant underreporting in relation to violence suffered by children and men, probably because of stereotypes. In the case of children, could be also related to the vision of children as property of parents, which is why there is, as with all other forms of violence, a misunderstanding about what constitutes abuse and maltreatment. In this way, a first barrier to access to justice is configured for the members of the family. And since it originates in the behavior of the state agents, it constitutes a form of institutional violence. With it, reporting is discouraged and intervention aimed at breaking the cycles of violence is made even more difficult. However, the fact that complaints are received does not guarantee effective access to justice. For example, in the case of sexual abuse behaviors against children, the tendency to use the figure of the alleged parental alienation syndrome has spread in the region. This is a figure which is contrary to the Convention Belém do Pará, the Inter-American Convention to Prevent, Punish, and Eradicate Violence Against Women. And it perpetuates gender-based violence and violence against children. Additionally, its use in judicial processes may compromise the state liability for institutional violence. Another example is characterized by the Inter-American Court in a case that does not refer to family relations, but that shows what victims of violence must suffer in the face of the judicial system. Ginette Bedoya Lima is a Colombian journalist who was victim of kidnapping, torture, and rape by an illegal armed group, with alleged tolerance on the part of the state and collusion on the part of some of its agents, who were aware of the imminent risk to her. In addition, she and her family have been victims of continuous harassment and threats due to her complaints regarding negligence of the state. According to what was proven during the process, the Attorney General's office called her 12 times to testify about her aggression, forcing her to relive the victimizing event over and over again. Similarly, her case was characterized by almost total impunity, because after more than 20 years, of the 20 implicated in the process, only 3 have been convicted. And no one of the masterminds of the crime has been identified. In addition, the negligence of the state has been such that the relevant elements that allowed obtaining the convictions were provided by the victim herself. In this way, another victimization action is specified because the victim is being forced to carry out all the investigations of her process, a task that it is an obligation of the state. As we can see, the violence set a burden that individuals have not the duty to withstand. In other words, the conducts of the state agents are the efficient cause of an unlawful damage that would permit the pretensions to claim their compensations. In this context, the Inter-American Court of Human Rights has established the admissibility of international liability of the states in cases in which they violate the due diligence standard, and if foreseen and evitable risk become real. Hence, the court has said that a better comprehension of specific crimes is reached if public servants consider the structural and systematic character of the inequalities and violence against certain group of people. According to its own jurisprudence, states have a positive duty of action to protect and prevent violence against vulnerable groups, particularly exposed to discrimination. For this reason, for example, it was possible to attribute liability to the states, even when the victimizing fact was committed by a third actor. This was possible when the conduct was exercised against discriminated group or through structural patterns of violence. In this way, the court presents a wider vision of the state obligations regarding human rights. This is an interpretation of equality that demands to abandon the idea of law as neutral to differences, in order to put the state as a main character of the problem. Thus, it must generate social balances, especially when we are in front of people historically discriminated or victim of structural violence, which is the case of women. This was the main consideration in the very known cases Cotton Field against Mexico in 2009, Prison Miguel Castro against Peru in 2006, Fernandez Ortega and others against Mexico, and Rosendo Cantu against Mexico in 2010. The last two involved also indigenous women, among others. In this case, the attribution of liability is founded in a specific negligence of the state for not prevent the violent actions of third parts or for tolerate them. These criteria contribute to integrate the concept of institutional violence to also include the irregular omissions in public service. This is particularly relevant in front of the violence exercised, for example, by armed groups, but also by third subjects against a person or group of people that belongs to a discriminated group. For example, women, because judicial praxis has demonstrated that public service is plenty of stereotypes that perpetuate the institutional discrimination through the categoric consideration about roles, attributes, and proper characteristics of women or any person belonging to a discriminated group. And it discriminates and leads them to a situation of severe violation of their rights. In this way, stereotypes can lead to violence when based on biased narratives. The administration admits situation of domination by which the administration admits situation of domination and subordination. Hence, this situation becomes worse when the stereotypes are implicitly or explicitly reflected in politics and practices, such as the legal reasoning and in the language of authorities. The state liability for institutional and structural violence could be a relevant instrument to face it, especially if the attribution is made in restorative key and considering alternative forms of symbolic reparations. This, of course, demands a process of education to public servants in the exercise of their function with an intersectional perspective, but also a structural transformation of the law programs at the universities, in order to educate in human rights, but in order to develop the capacities to recognize the historical discrimination that women suffer in this moment, identifying how some stereotypical ideas and values impede the realization of human rights. Thank you so much, Chiara and Valentina.
Natalia, thank you very much. A very insightful presentation, and I think that we have seen how both in the law that creates rights and in procedural law and in enforcing law, we can see how gender is relevant and explicitly or implicitly in other cases. I don't know if Valentina have some comments. No, okay. She will speak in the end, probably. I don't know. And so I leave the floor now to Professor Ferreira. He is Professor of Law at the University of Sussex, and he is a real expert of the relationship between gender orientation, gender more broadly, and asylum law and migration law, and today he will give us a presentation on the topic of the invisibility of families in the context of international protection on grounds of sexual orientation or gender identity. And I think that in that case we will see intersectionality at work, and so I leave the floor to Professor Ferreira.
Can you hear me now? Yes.
Yes.
Right. Then good afternoon, everyone. Thank you so much for the introductions, Chiara, and thank you to all the organizers, Chiara Angiolini, Valentina Calderai, and Aleksandra for the invitation and facilitating our participation here today. I have some slides that I would like to share. I don't think they are showing yet, are they?
Yes.
They are.
Yeah, I can see the slides. Yeah.
Okay, then I'll start showing the slideshow. Please let me know if something doesn't work, because my laptop seems to be a bit slow today. All right, so I'm going to present some findings from a project called SOGICA. and SOGIC stands for Sexual Orientation, Gender Identity Claims of Asylum. And it was a project that I ran between 2016 and 2020, together with a group of 3 research fellows. And we explored a range of legal and social experiences of asylum claimants in Europe claiming international protection on grounds of sexual orientation or gender identity. We produced lots of articles and book chapters and so on, but there was a topic that we didn't cover in those books and book chapters, and that I was very keen on working on, which was precisely the family experiences of those claimants and whether they had access to international protection or not as couples and as families. And so together with my colleague Carmelo Danisi, we worked on a journal article that I'm going to present today. The article is basically the result of many of the themes that came up during our interviews with participants. We talked about how the asylum process in Europe interacts with how our participants saw love and family life and childbearing. And so we wanted to explore that in a separate piece of work. And we, throughout our field work, we noticed a lot of tension between what the guidance and the policy said and exactly how decision makers were taking decisions in practice. So in the journal article, we explored those tensions. And we also look at how the UNHCR, the United Nations High Commissioner for Refugees, guidelines for sexual orientation and gender identity claims of asylum